Hey, everybody, this is Kathy coming to you straight off of the premiere of our latest content. It's, I think, really important to try to get word out there. This is yet another unscheduled live. And what I wanted to point out is some crucially important language that is contained. Hi, Christina. Thanks for being here. That is contained in that 13-page memorandum that Judge Megan E. Marshall signed on October 1st, 2025, when she entered the permanent injunction against the city of Moscow. I know from the feedback that I'm getting on my podcast, which appears on multiple platforms, here on YouTube, people are very concerned about what the implications are relative to free speech, free press, with this ruling, which has enjoined, that means prevented permanently, the city of Moscow from releasing certain public records from the Moscow Police Department's investigatory files, including body cam images. This would possibly be the photographs, the 15 of them, that first responder Corporal Snyder took within the minutes that he arrived at 1122 King Road. I know that you've been watching the body cam videos. You've seen him walking through the house. You've seen him go to the second, the third floor. You've seen him up on the third floor taking photographs of Madison's bedroom door. There are 15 photographs he took inside Madison's bedroom. There's body cam imagery that it looks like 4 of the 5 first responders, Nunez, Warner, Gunderson, and Snyder, have walking through that house. It appears that there is no body cam footage for the 5th Moscow Police Department first responder, Corbin Smith. A deep concern, in my opinion, that he would be in that house, walk through the house, communicate. We got some of his communications on body cam when he's communicating, for example, with Warner. But what did he do at 4 p.m., ladies and gentlemen, November 13th, 2022? Who recalls? Who recalls what Corbin Smith, officer of the Moscow Police Department, first responder, document number 1 on the City of Moscow website, those hundreds of pages of narratives that they released? His narrative is there. Doesn't say anything about his body cam being out of commission. Doesn't say anything there. What did he do at 4 p.m.? Thank you, guys. Wow, I can't believe it. I got more than one person here. Being that we hadn't advertised, this was last minute as per usual. Let's look, Christina, thank you. Gee Whiz is here, wow, with the thumbs up. Amy's got her coffee. Amy, you got a strawberry. You always bring food to these chats and these lives. I appreciate it. And we've got Connie, beautiful day in the neighborhood. Thank you for your work. It's my pleasure. Leslie and Billy, wonderful to see you here. Gee Whiz, again. Yes. Gee Whiz on top of things. Gee Whiz has, how many times have you read the affidavit of probable cause? Written by Detective Brett Payne, although I call it a declaration. It's not, I don't see where any, like a notary public, if you've got to get something notarized, I see no notary signature. It's a declaration, in my opinion. It still does what it needed to do. It certainly got the warrant issued. It certainly got Judge Marshall to be convinced the probable cause existed. Gee Whiz, too many times. Gee Whiz is saying, how many of you agree with Gee Whiz that it's probably too many times that you've looked at the affidavit of probable cause, the 18-page document number 1 in the matter styled as Idaho versus Kohberger, that was opened on December 29, 2022 and closed very dramatically on July 23rd, 2023. 5, while many people were anticipating this trial. Yes, too many. You're sitting in your emergency room, Leslie and Billy. What's going on? Hope everything's okay. Hey, Rebecca, thank you for being here. Connie, thank you for being here. Christine is saying that you've read the affidavit of probable cause too many times. Page 1. Page 1 of the affidavit of probable cause. We're going to skip past paragraph 1 where Payne goes into his credentials, who he is. You got to go to paragraph 2. Paragraph 2 says, at approximately 4 p.m., he arrived at 1122 King Road. Did he drive there by himself? Was he not accompanied by someone? Was he not accompanied by a sergeant who's now been promoted to a captain right now? Wasn't he accompanied by the very person who traveled from Moscow to Meridian, picked up the DNA profile, was around November 22nd, picked it up at the Idaho State Police lab and took it on a plane through X-ray, through Homeland Security, all the way to Othram, no sheath. That was who Detective Payne drove over. Who knows his name? Prayers for Leslie and Billy. Absolutely. Is everything okay, Leslie and Billy? We'd like to hear from you. From what we understand, Leslie and Billy are sitting in an emergency room right now with their mother. Okay. Roll them out. A lot of questions. It was Sergeant Blacker, right? Who drove over with Detective Brett Payne, lead detective in the case, author and signatory of the affidavit of probable cause, which asked on page 18 for the warrant for Mr. Kohberger's arrest based on everything that came before page 1. Very important information on page 2, the discussion of the sheath that no one in the public has ever seen. Page 1, he says, as Gee Whiz very correctly recalled in his too many readings of the affidavit of probable cause, it was Corbin Smith who met Detective Payne, who had been driven or drove, not sure which one drove over. They just had probably come from the Moscow Police Department where they did their interviews. One did an interview of BF. Someone else did an interview of, who did Payne interview? Oh, JD. Thank you, Connie, for your kindness. I appreciate that. Critical thinking and common sense is a breath of fresh air. I keep asking myself, why did Brian take a plea? His attorney should have had access to all of this. Everyone, I think a lot of people here agree with you, Connie. Getting back to Detective Payne when he arrived, it was Corbin Smith who brought him upstairs into the home, right? They traveled, they entered the front door. They went up to the second floor. Corbin Smith led Detective Payne to Xana's room where Xana and Ethan were. And then they made their way upstairs, possibly right over the latent shoe print that no one talks about anymore. That was mentioned in the affidavit of probable cause. Remember the Vans like shoe print. Where is that? Whatever happened to that? Went upstairs, and he says, according to the PCA, page 2, that he later noticed, possibly during the 5 o'clock walkthrough that we only learned about when the ISP released records. Second time he walked through Payne at 5 p.m. That might have been when he saw the sheath. So we got Corbin Smith. I certainly hope that there's body cam of that tour, right? Can you imagine if they come back and say, oh, Corbin Smith, yeah, his battery was supposedly dead, and when Warner gave him another battery, still didn't work. It was reloading. Let's hope he got the problem fixed as he continued to work 1122. By the time Brett Payne got there, let's hope that walkthrough is on body cam. Let's hope the second walkthrough at 5 p.m. after they received the warrant is also on body cam. Payne walked through a second time with Blacker, with the head of the ISP for the crime scene. It was the detective, and with a certain attorney, William Thompson, and with a certain attorney, Ashley Jennings. Those were the 5 that walked through the second time. How many people were allowed in this house? Coming in, going out. I think that there's a principle that you want to limit the crime scene. You don't want to be doing things like taking things out, in my opinion. As Gunderson took out that dog, Murphy, what if Murphy had evidence on him? Why not cart Murphy? He had food, he had water. Then take him out. He might have had some critical evidence on him, and ISP had not arrived yet. ISP, we know from the documents, 12:22 p.m., 13th, Moscow Police Department reached out to them and said, we need help. They were the ones that processed the crime scene. They were the ones. It was there. So what is the reason for taking it out? Oh, Joe, Emma, who else wants all the points on Kathy's quiz? I think I put the answers right there on the time. I used to publish some content giving the answers and the explanation, but I usually do it right there in the comments, the answers to our quiz. And Connie is pointing out Kaylee is missing a sock and an earring while Ellie was contaminating the scene. Why no shoe covers for Ellie? I would like an answer to that, Connie. I'd like to know, why was it? And not getting too graphic here, but you have 4 people who were unalived in the way that they were. This means that there were fluids that were seeping for hours by the time they arrived. People aren't walking in with masks, hazmat. Something's just not making sense or adding up. Okay, so Amy's saying Barrett, yes, first 48-hour lead. Okay. Let's go back to what we're all here for today, because I have some very exciting news for you. This is why I spend my days and nights going through these documents. I'm very older than many of you, I believe. So it's literally episode 1 of the podcast, page 1 of the affidavit. It printed it out or had it up on the computer, and literally with a ruler and a highlighter went through it line by line, pointed out all of the inconsistencies, such as how possibly could Kaylee and Madison be at the Corner Club at 1:30 a.m. on the 13th, and also simultaneously be at the Grub Truck at 1:30 a.m. Impossible. The typographical errors. All the things that we're finding out now in retrospect, I think that were important, as in there was a second walkthrough that he made at 5. That one of the first responders apparently had no body cam, the one that escorted him. And all of these other things that you guys are questioning and saying, my goodness, 1 and 1 just is not adding up to 2. 1 and 1 isn't even adding up to 3 in many people's opinions that we give under the First Amendment to the United States Constitution, freedom of speech and of the press. Al, so happy for you to be here. Al's heart is broken over seeing Murphy. Agreed. Thank you, Al. Thank you so much. Appreciate it. Thank you so much. I have exciting news here today. Has anyone read? I know how disappointed everyone was, concerned, shocked, saying this is the final nail in the coffin between Judge Hippler, who's taken his time. I'm revising my opinion that it's probably going to take 2 years before he gets to the beginning of the 2023, January, February, March, getting to all of the evidence that Judge Marshall sealed from the public, right? Probably going to take about 2 years. So in conjunction with that, now we get hit with this injunction for people that are interested in this case from a First Amendment perspective, who have concerns about how this case was handled and the precedent that this case could set. That a case this high profile that garnered global attention could be as secretive as that case was. And then a month before, weeks before the jury was about to be selected, oh, there's a plea deal. No trial. No, well, what about the documents under seal? Then there is this injunction that just came out. Did you guys read the injunction? I mean, it's one page, but as I'm going to quote Harsh here, Harsh Reality, who I thank very much. He shared several of my videos. He sent people my way. I appreciate it. The meat and potatoes, the whys of how Judge Marshall arrived at what she declared in that final judgment is in that 13-page memorandum. 2 documents that were issued on October 1st, 2025. If anybody, thank you. Oh, my pleasure, Matrix. Please, if you don't want to read the 13-page paper, totally understandable. We got a multiple part series coming out for you. We're up to episode number 4. There's probably going to be, I think it's 6 in total. We're doing 2 pages at a time. We did pages 1 and 2, 3 and 4 yesterday, 2 separate. Then this morning we published the next chapter, which was the next 2 pages, but the one this afternoon, there is a key piece of information that I think a lot of people are not aware of, what Judge Marshall had to say, because, right, she's interpreting the Idaho Public Records Act. This case is over now, right? There's no reason to keep sealed all of the MPD's body cams, photographs taken by Snyder, photographs taken by Smith, photographs taken by anybody else. Hey, what about Warner? Who knew that Warner took photographs of HJ right outside the front door, asked to see his hands, and then later calls him my homeboy? I think Warner had some questions there, had some serious questions of somebody running around with, this type of a weapon 12 hours supposedly after, or 8 hours after the crimes occurred. Lots of questions I think he had. If you don't want to, I can totally understand. It's stressful reading. It's hard reading sometimes, but we will cut to the chase. We'll walk you through it. Watch, please, the multiple part series that we're putting out. But the most important of all, so far, I think, is this last one, episode 4, because of what Judge Megan E. Marshall declared at the bottom of page 7 and the top of page 8 of that 13-page document. And I want you to, if you possibly could, share it. If you know of anyone who filed a public records request seeking documents from the Moscow Police Department, where the city of Moscow, up until the time that Laramie versus City of Moscow was filed, which was August 12th. So the window is, I think it's July 23rd when the case was closed, through, let's say, August 11th. If you know, I know content creators have filed public records requests. I know that the plaintiff in the federal lawsuit, the Idaho 4 defamation case, she actually tried to enter the case in Idaho versus Kohberger, and Judge Hippler said, oh, no. It was you'll see it. You'll see it. It's in May of 2025. And so she was looking for documents from the case file, told no. If you know of any content creators, citizens, anyone who filed a public records request and received redacted information, redacted photographs, like, remember some of the earliest stuff that came out was from a member of the media, and they published photographs in Ethan's room or Xana's room, and there's blurred out figures there. We got a bombshell from none other than Judge Megan E. Marshall herself. The bottom of page 7, going into page 8, she's interpreting the Idaho Public Records Act and said that before the lawsuit was filed, the statute required the city of Moscow to respond with unredacted information. They had no authority to redact anything. Might be worth a try for people to go back if they were told no. and say, okay, I was told no. Here's what Judge Marshall's saying. Here's a memorandum explanation for the final judgment enjoining. But she's saying here, as it relates to my public records request that I filed on July 31st, asking for everything, including body cam footage, she's saying that you were supposed to submit them unredacted photographs. And what everyone here, I think, if there was one photograph or one body cam image that you would like to see as a researcher, as people that are interested in the First Amendment, as people who understand that the public is the checks and balances to make sure the courts and law enforcement and government are doing their job and not abusing their power, if there was one bit of evidence that you could see immediately, unredacted, no questions asked, what is it? Hey, Matrix, if someone requested it before August 12th, 2025, we got the information right here from none other than Judge Marshall. First, she signed. She signed, right? The order finding probable cause. She signed the warrant for Mr. Kohberger's arrest. She was the first jurist in the case. She signed the first non-dissemination, aka gag orders, in January of 2023. There we go. There's Rebecca. Rebecca's not even hesitating. She wants to see this sheath. Well, from what Judge Marshall's saying here, bottom of page 7, top of page 8, she's saying that they were obligated. She read from the statute itself. They had no right to withhold any information. That's reports, that's photographs, whatever people asked for. Give me your entire file. Body cams from the 13th of November, photographs taken that day, all reports of the first responders. Okay. To say that someone had a privacy interest in that room on the 3rd floor where that sheath supposedly was, Judge Marshall saying that those documents should have been unredacted. Now, if you file a request today, this I was going to call it a gag order, this final judgment of enjoining the city, you're out of luck because she's now rendered this ruling. But she has also said from August 12th and backwards, these are the public records requests. So if anyone knows, Al's again, she's saying, undoubtedly, we have to see the sheath. We have to see the sheath. Gee whiz is just, he's shocked. Holy moly. Because I know that Gee whiz has been saying for a long time, he's a fast supporter of the First Amendment. He's concerned about this case. He wants to see the sheath. He doesn't want to hear any more descriptions about what Detective Payne, accompanied by Officer Smith, with or without a body cam operating, we don't know at this time, has to say. We don't want to hear what Bill Thompson has to say. Gee whiz does not want to hear what Ashley Jennings had to say. Gee whiz does not want to hear what anyone has to say. Gee whiz wants to see what Brett Payne said was visible from the door later when he saw it. And that's that sheath. That sheath is this entire case. That sheath was the single most important, at least in my opinion, evidence against Mr. Kohberger. Is it possible that today, it's almost 3 years since these catastrophic events happened, and no one's ever seen the sheath in the public? They would have had to bring it into the courtroom during trial, right? That was their star piece of evidence. When a certain Judge Stephen J. Hippler presided over hearings back in January on motions to suppress evidence, what did he tell? What did he say in January to Mr. Kohberger's attorney? When they were challenging the order finding probable cause signed by Judge Megan E. Marshall on December 29th, 2022, based on and in reliance on what was said in the affidavit of probable cause, claiming that that sheath was visible from the door on the bed where two of the victims were found. Judge Hippler, yes, yeah, Elle's right. And yet I've seen it today. It's shocking that this case went for more than 2.5 years. It's been closed. It's over 3 months since Mr. Kohberger pled guilty. This isn't about the Fifth or the Sixth Amendment, whether he pled guilty or didn't plead. This is about the public's right to know. And so many episodes of the podcast where here we go. Another order sealing discovery from the public. Yet another document sealing evidence from the public. Yet another document sealing this from the public, sealing that. It was over and above, in my opinion. Some of those objections, in my opinion, made 0 sense, i.e., one objection that both sides signed in a stipulation said, this evidence needs to be withheld. That's what sealing means. It needs to be withheld from the public because if it's released to the public, it could pose a threat to unknown, unnamed people, plural, safety, and lives. Now, when I saw that, the first question that I asked, Moscow Police Department, the state of Idaho, has never arrested anyone else, has never made inclination that anyone was involved before the fact, after the fact, was a co-conspirator, was the actual person who perpetrated the crimes. Nothing. They have always said it's Kohberger, sole and the correct defendant. If Mr. Kohberger has been continuously behind bars since December 29th, 2022, when he was booked into the Monroe County Jail and then was transferred, didn't fight extradition, transferred via that teeny tiny plane of remember, Pennsylvania State Police, it had to keep coming down for gas refills because it had such a small tank, finally made its way to the Moscow Pullman Airport. He's then taken immediately to the jail there in Latah County, and then he was taken to the jail in Ada County once change of plea happened, and then finally his final destination, the penitentiary. Is he given day passes? That's what I asked. I said to both of them in my mind, you're signing this, Ms. Taylor. You're saying one of the good cause is because if this information's released, it could be a threat to someone's safety or lives. Is Mr. Kohberger getting day passes so he can get out of jail and go out and effectuate some sort of revenge on whatever information that you want? And they got sealed. Then there was, they're going to seal all jury instructions. Well, in Judge Stephen J. Hippler's October 9th, 2024 pretrial and trial order, where he set the trial date, page 1 that was supposed to be July 30th was going to be jury selection, and then I think it was the 12th of August was going to be the trial. If you go to page number 4, that's where they get into all the pretrial stuff. The in limine motions on page 2. Then they get to jury questionnaires, jury instructions, witness list, all of this other stuff. Everything was supposed to be sealed except the jury instructions. Hippler never ordered the jury instructions to be under seal. Jury instructions, to a great deal, are standard documents that's used in every criminal trial, such as the state has the burden of proof beyond a reasonable doubt of admissible evidence to prove their case. And the person sitting in front of you has a presumption of innocence, and you cannot make any presumptions against him. And the judge is the trier of fact. The judge is the trier of fact. That's what this judge is, the trier of law. That's what that means. The jury is the trier of fact. That's what that means. They're used in every case. Every single jury instruction was under seal. What are you guys saying here? Matrix is saying no autopsy reports were released. Well, if someone requested that public documents information, Judge Marshall said, the Idaho Public Records Act, you don't have to give a reason for it. It's automatic. You make the request. It's got to be fulfilled in an X number of days. There's six statutory exceptions that allows you, as the city of Moscow, to redact or not release information. That's it. That's it. Oh, wow. Phenomenon has mailed U.S. senators doing something. That's the way. Proud of you. Round of applause for Phenomenon. We all have to do that, myself included. Contact your federal legislators because this is a federal issue. How the First Amendment to the United States Constitution is not being upheld, I don't think. Hey, Christy's in the house. Christy, glad you're here. If you could be here late, well done. We'll take it. Okay, so now we have, whoa, Matrix. Christy made a FOIA request. Well, no, this is under the state statute. Christy, did you file a public records request with the city of Moscow for anything from the files? Because we're trying to get word out. Pages 7 and 8. Judge Marshall made the ruling in this memorandum that the city of Moscow should not have redacted anything up until the filing of the lawsuit. Then it's a different story. But anyone who filed a public records request prior to might want to go back to the city of Moscow and say, hey, page 7 and 8, here's what Judge Marshall has said. You were supposed to give me unredacted evidence from the Moscow Police Department's files, not redacted. So I'll give you 10 days to get them to see what they say. They may come back and say, oh, well, Judge Marshall has said that the city's now enjoined. Yeah, but that's a public records request made after the lawsuit was filed, not before. Okay, let's, Lana did. Very good. Get word to her. I know that she's looking at this document, but it's almost like it's hidden. Guys, this is a 13-page document. Really 12, because page 13 is the certificate of service. Bottom of 7, top of 8. That's where the magic language is. Where Judge Marshall is saying that the city of Moscow had no business under, and actually, in my opinion, violated the Public Records Act by sending out redacted, whether it's body cam footage, whether, whoa. Christy, breaking news here from Christy Chaos. Christy here is saying, I FOIA'd over 100 items to Moscow. When, Christy? When did you send? Now, again, the FOIA is the federal statute, which I think Jules did try. I think I read something that she tried to, and they told her no, but that's under the Federal Freedom of Information Act, which Judge Marshall talks about here. We're talking about if it went to Moscow, if you sent it to the city of Moscow, you're not sending a FOIA, you're sending it under the Idaho Public Records Act, the IPRA. When did you send your request, your public records request, Christy? I can't get my Rosie video to, okay, we'll never see as they were done in Washington. Okay. We need to sponsor Christy and send her a bunch of heavy-duty hard drive. Oh, Chris. Whoa. Breaking news right here. Christy is saying that she sent a public records request in May and June or July. July. Okay, very good regarding the May, June, and the beginning of July, middle part of July. The crucial time period, the best chance to get maybe some traction going, possibly. And again, I'm just giving an opinion here, speculating, First Amendment, no legal advice, nothing. I'm just reading what the judge said here. July 23rd, that's the crucial date. That's when the case was closed. Hell yeah, Matrix is very happy about something. We're about to get a mother load from Christy. Matrix. Everyone, yes, be sure, everyone, to subscribe. Christy's Chaos has a new channel. She did a dynamite presentation earlier today. I was able to watch part of it. And make sure you set your notifications, because who knows? Maybe one day Christy will receive some unredacted records that she asked about. And maybe Christy's going to be the one to have the smoking gun of what Detective Brett Payne, page 2 of the affidavit of probable cause, Gee Whiz's favorite document. He has read it too many times. He said, is Gee Whiz still here? She might have that evidence. July 23rd. That's the date the case was closed. From then on, hey, should have been no reason to withhold anything. What? Rollo Moda. Eric EG's wife is who processes all of the FOIAs. Very interesting. Very, very interesting. Wait. L, breaking news, everyone. Breaking news. I need to have a whistle or a bell or something like that. L is saying that she sent a public records request on the 25th of July. This would have been 2 days after Idaho versus Kohberger was deemed a closed case by Judge Stephen J. Hippler. That's on we can find that and prove that very easily. Idaho versus Kohberger on the case summary page, as well as the public docket. L is saying she sent a public records request July 25th. You didn't get a response. L, what'd you ask for? What'd you ask for, L? And what did you get August 19th? Gee Whiz is too many times reading that affidavit of probable cause. Okay. L here is breaking news. L is saying she just recently went back to look at everything, and I asked for a beep ton of everything. Well, L, you might want to consider going back. Matrix, that's so insane. Hopefully she dumps it all like she did him. It's possible he drove KG to purchase her car. And yeah, that Hayden, very, very, very interesting you bring that up. That one interview that was done of the person who purchased KG's car, saw her get into a car with someone, couldn't describe what it looked like according to the record that was produced by the Idaho State Police. We haven't heard any narrative. We understand that it was a telephone interview and it was recorded. I'd like to hear the recording myself, because things just don't come out the way it says here. Christina's laughing. She loved it. Beep. Yes, we have to, make sure, because there are young children, I think, in the audience that might be here, and we've got to be very, very careful. I don't want to lose my FCC license, my little independent podcast. Okay. Oh, got a letter telling her no. And the reason I failed to give my physical home address, which is ridiculous. I have 180 days to appeal. So L's going to appeal this. L's going to appeal this. L, go ahead. Make sure, keep us posted. And please be sure to attach Judge Megan E. Marshall's memorandum highlighting pages 7 and 8. And keep us posted, please, as to what happens. Very good. Okay, so we have potentially 2 content creators, very much proponents of the First Amendment, L and Christy, who one day you might, it's not inconceivable down the line, tune in and see that they've got what you've been looking for almost 3 years now. Evidence that a sheath even exists. Evidence of what it looks like, right? Evidence of what condition it was in. If it looks like, well, we can't do this compare and contrast, because the receipt of what Mr. Kohberger allegedly purchased from Amazon, remember that came out in discovery. Oh, there's a receipt. It's an Amazon receipt. A K-bar, a sharpener, and a sheath was supposedly sent to Mr. Kohberger, purchased on a gift card of some kind to his house. Why don't they release that as opposed to pictures of him and video of him walking around Albertsons? Is that a red herring? That's irrelevant. This is after the crimes for people to discuss things like what's he wearing, his hairstyle, how he's interacting with other people. Why not show us the receipt? Because as far as I know, I'm not an expert at all in K-bars. As a matter of fact, I never even heard of them until this case. But people could then do, because you guys are very good at research, people could go out, gee whiz, you might decide to go on Amazon and look up what this supposed sheath looks like and compare it. If L and or Christie come through, you might be able to do a compare and contrast on behalf of the citizens that are very interested in this information. Mueller report. Oh, Amy, always coming in with the stuff that I forget. Please, Amy is saying, please hit the like button. I would greatly appreciate that. If you've not subscribed to the channel, please do so. Please hit the notifications button, because we are going through line by line by line by line this current memorandum to see what else we can find in there that might be helpful. I don't know of anything that can top this bit of information. Bottom of page 7, top of page 8. Gee whiz is saying he's got confidence in you guys. He's got confidence in the ladies here. He's thinking that, Christy and Elle are going to come through with this. Just keep everybody posted. Amy is coming up with a great point. She's saying that this is distractions. She's saying that these are red herrings. This is intended to get people to look over there when the real important stuff is to the left, not the right. So Rollo's saying a receipt without a date, only estimated time of purchase, like 6 months period. WTF, beep, on the F right there. Along with Hillary's, what happened? Okay, so we're getting a lot of comments here regarding the case. I wanted to also turn to your attention one of our most recent podcast episode. Idaho versus Kohberger podcast preceded this YouTube channel by about a year and a half. The Idaho versus Kohberger podcast, 5 minutes or less, curated that entire docket. We started out with page 1, affidavit of probable cause, went through page 2, page 3, page 4, page 5, page 6, all the way through page 18. Those were the first 18 episodes of the podcast. And I was going to stop right there. I thought, I'm just going to do the affidavit of probable cause. And then, because I was considering doing a multitude of cases. And I said, wait a minute here. Okay. 1 + 1 is not 2. It's not even 3. It's somewhere around 2,650. I got to focus my attention on this case. And I did. And so for the next 850 episodes, it is literally everything on that docket. And you know my feeling, you guys, people who follow this channel demand to see the documents for themselves. They don't need me to tell them how to formulate their opinion. But what the podcast will do is, if you're interested in a topic like sheath or IgG DNA or change of venue, or how about under seal, that's going to be a big return for you if you use the search engine on YouTube here. It will pull up all of the episodes that we did as the docket was updated. That's what that podcast is for. It is that docket is not searchable. There's titles of documents that make no sense, that you would never know what it's dealing with. The podcast will tell you, if you're interested, if you want everything on that docket regarding IgG DNA, and you put in IgG DNA in the search engine for the podcast, it's going to pull up the episodes. It'll tell you the date and the location, the title of the document. So then you can then go over to Idaho versus Kohberger and read the documents for yourself. So started to do this podcast, and the questions just kept racking up. And I thought, okay, well, they're going to go to trial in October, right? Before he waived speedy. And how about when Judge John Judge said he himself had gotten summons for jury duty? That's how small Latah County was. And so how do you guys feel about now in retrospect? We have the benefit of being Monday morning quarterbacks now and looking back and considering. How many of you feel in now in retrospect that it was the good call to waive speedy? So then what that did is it then relaxed the federal constitutional requirement that the state needed to be prepared to try their case within, I think, 160, 180 days. I forget what the number is. But it would have been, I think it was set for October 2nd, 2023. That was the date of the first trial. Do you feel that he should have gone to trial in October of 2023 before Judge Judge? Or do you think that it was, a good point? I was listening to A.R. Hayes last night on this topic, and he has said, based on his experience, that it sounds great in theory, forcing the government, but you got to be able to come back with something, and it takes time to develop an alternative suspect or an alibi defense, even though nobody is required to say a word in court when you're a defendant. That's what he found. Then there were some that said, hey, I wish that this thing would have gone to trial in October. It might have gotten a better result in retrospect under Judge John Judge as opposed to Judge Stephen J. Hippler. Yeah. Oh, Chrissy, you were supposed to be on AHAR. You guys were great. I think you did one a while back. You were really great. I learned a lot. I hope you'll be able to do another one with him. He's advocating for, we got to go beyond just doing content. We got to let our voices be heard. I think that was AR's wife who challenged him with that. And so he's now thinking, what can people do now besides? I think that sharing content's important because it raises these issues to other people. And you can't fight a battle like this with two people. You need a lot of people that write to their senators, like one of you said, about this case. Good. Christy's saying that she's going to go with AR again. So, it's hard to know what would have happened, would have been the outcome. Ms. Taylor had a lot of discovery that was still pending at that time, but I don't know. I don't know this focus. It just seemed like so much of the case was focused on IgG DNA. They brought Bicca Barlow, an IgG DNA, old school strategic add to the defense team. And then when the in limine motions came out, we're not going to use anything having to do with IgG. Well, why'd you spend 2+ years fighting so hard on that issue and maybe not trying to raise reasonable? I don't know. Amy is saying the preliminary 6 months. If state not ready, then they have to drop the charges. But says the judge wrapped. Oh, okay. So Amy is she has a tendency of doing, because I've known her long enough. She's been a follower for a while now. She looks at both sides. She's going to look at something from the state side. She's going to look at something from the defense side. And her opinion is, going to trial within 6 months. Kathy, she's saying here, sounds great, because if the state's not ready, they got to drop the charges. But then, on the other hand, against the defense, Amy's saying that she was a little concerned. The judge was right there from Latah County. He went to the University of Idaho, as Ann Taylor did, and a lot of other people in the case, Bill Thompson, all the way down to Corbin Smith. I mean, everyone, it seemed, so many people went to the University of Idaho. It was a very small, really small town in so many different ways. So she's saying, while it sounds good in theory that the state's supposed to drop charges if they're not ready after 6 months, she still has her concerns about how things might have went for the defense anyway. And CH is chiming in. 6 months is a possibly long time, short time frame for it's a DP case, right? In the digital age, speedy to DP should be extended for 1. Oh, this is a great point. CH is suggesting, okay, if this is a burglary charge, if this is a DUI, if this is, let's say, even run of the mill unaliving, because there isn't any run of the mill. But if you're talking about a DP case, 6 months, good enough for everything else, but you need a year to prepare for a DP case. It's a capital case. You know, it's someone's life. It's not just liberty. It's a life that's at issue. Good point. Good point. Yeah, Rollo. Yeah, I'm not going on screen. I did it. I'm protesting. You know, the First Amendment says that you can petition government for grievances until Judge Stephen J. Hippler releases some more documents on this case. I'm just doing a little protest. I'm actually doing it. I got my little, room here where I tape and everything, and I walk around with a picket sign. Judge Hippler released some, Judge Hippler tear down this wall. Remember, I don't know if you remember from history books what Reagan said, that is infamous quote. Judge Hippler opened up the case, right? When he does, come online, no worries. I think AT should have pushed forward with Speedy, and if state doesn't meet the discovery deadlines, DP is taken off. The validate, fair enough, CH, when all of that stuff came down in May, when Judge Hippler put out those 2 orders, remember how terse he was at the final pretrial conference when he came out and said, it's been brought to my attention that there has been a quote-unquote leak of the non-dissemination order. I thought that would be a good opportunity for the defense to say, take the DP off the table. Clients' due process privileges have been destroyed here. Even Judge Hippler said, it's going to impact the seating of a jury. That's 14th Amendment issue, entitled to a fair trial. And this was a trial by jury, not by judge. Executive state needs to prove their case. Yes, 2020, no doubt. Reigning Rebecca, we are absolutely doing 2020 here. But what about, I want to throw something out to you that's been bothering me since change of plea. People have said they remember where they were when the news broke. I think it was maybe around Monday, July 1st. I had a live that day. And someone came in and said, I think it was News Nation has broken the story that there's a plea deal. And we're like, what? They could not have been more head butting in this case than there was, right? You got the one hand saying, this is a DP case. He's the sole and the correct defendant. The other one saying, no, he's not. Not only you're not going to be able to meet your burden of proof beyond a reasonable doubt, he's factually innocent. And now they've ironed out a plea deal. It was very, very disconcerting because I, for one, having covered this case for as long as I have, having had an interest in this case as just a citizen, podcaster, everything else, I wanted justice to be served properly for Kaylee, Madison, Xana, and Ethan. And I don't think that's going to happen until the public had the jury trial that had been waited for over 2.5 years as the case proceeded under seal. Then to hear no jury trial, but then, well, what about all these documents, Judge Hippler, that you signed all these orders? What about all the orders that Judge Marshall signed going back to January of 2020 about the evidence? Where's the evidence? Show us the evidence. What about Judge? They did their part, all 3 of them. There's so much under seal in this case. You got to look at the case summary page to understand just how much is under seal. So then we had, right? How many times did you hear Ms. Taylor either file something, a motion or a response or a reply saying that the defense hasn't gotten their discovery and they're not prepared to go to trial? They're just not prepared. I recall her saying that in open court many times. And then Hippler asked her point blank, Do you have all the discovery you need? And she did a little smile and she said yes. Where'd that come from? Didn't she just say, like, days before, weeks before, months before, the exact opposite? The thump was Xana falling to the floor. Yeah, that's heartbreaking. It's hard to look at some of this evidence. I don't like it, but the public is entitled to have that case unsealed. It's bottom line. I don't want, enough of this, privacy rights, this, that, and the other. This is the public's right to know. It's the First Amendment issue. It's an issue under the state law. We've got this person who has been behind bars now for almost 2 months. And the public's never seen the evidence in the case. Could he have done it? I mean, these scenarios go from he did it by himself to he's a scapegoat to he did it with help. He was an accessory before the fact, accessory after the fact. He helped with the cleanup. He was in the wrong place at the wrong time. He was a patsy. Any one of these are possibilities. And the reason why is because this case was sealed. If they would have released the evidence along the way, some of it, the public could have said, okay, I get it. I get where the defense is coming from. I get where the state's coming from. But they both hid this case, both of them. It's not just the state, it's the defense. And as a matter of fact, it was Ms. Taylor who drafted the first version of the non-dissemination, aka gag order, convinced Thompson to sign it, and they presented it to Marshall on January 3rd. That was the first version. That gag order was not set aside until mid-July, 16th, I think it was, after the media got involved. Even then, Taylor was fighting against that gag order being set aside. She wanted no cameras in the courtroom after the media who were in the courtroom kept taking photographs of Mr. Kohberger, close up his hands, all this other stuff. She wanted all cameras out of the courtroom. And that's when Judge said, okay, media, you're kicked out. No photographs, no nothing. But we're going to transmit the hearings, the ones that are open over the courts system. Hey, Heather, glad to see you here. Gee whiz, I don't think some reports was written until Anne asked for them. Yeah. Oh, gee whiz. A lot of those reports are dated like July 6th, June something. Quite a few of them already say on their face, Gunderson's report for November 13th, 2022. He says it was written on, I think it was January 24th, 2023. That's what, 3 weeks after Mr. Kohberger's arrest? Why didn't he do like the other 4 first responders did and write that report on the 13th of November? That's what they signed under oath that they did. A lot of questions. A lot of questions. Okay. Any final? We're coming up on an hour. I didn't want to keep you too long. Anybody have any thoughts, any comments regarding the recent final judgment in joining the city of Moscow, the potential hope potentially for transparency that there might be at the bottom of page 7, top of page 8 of Judge Marshall's memorandum dated October 1st. The continuation, we haven't seen any documents since unsealed at all, redactions or anything, since September 3rd from Hippler. It's been another month that's passed. Okay. Rolo saying, I've been saying this 2 years ago. Heather, I don't know. Heather, I wish that they would stand up and do their jobs. You know, there is a motion that the media filed in mid-July that said, not the one to set aside the non-dissemination order. They filed that on July 3rd, but there was one that they filed a couple weeks later. And attached to it was an affidavit from a reporter of the AP Associated Press who said she has worked in journalism for 25 years. She went to the University of Idaho. Her first job was working for the Lewiston Press. Then she took a job with the Associated Press, I think in 2002, 2003. She's done work. She's worked law school, continuing legal education. She's supervised people. She's been a hard beat journalist. She says that she has exclusively worked on the courts and has reported on multiple criminal trial. She was responsible for following and to writing about the Idaho versus Kohberger trial. She has said in her entire career, she has never seen a case that was sealed like this one was. In her declaration, and she went into the First Amendment, she said that there was an air of secrecy in this case like none other. She said that the orders to seal started to skyrocket in January. That must have really thrilled Judge Hippler on that one. Hey, Annette, good to see you here. And but the press here, the fluff that they're printing. Oh, let's talk about Mr. Kohberger walking around the Albertsons. Oh, let's talk about Mr. Kohberger not being able to get into, another store. Let's talk about Mr. Kohberger's selfies. Does he look odd? Not odd. His eyebrows look like this. No, they don't. Let's talk about his apartment where they found nothing. They're doing all of that, and the magnum opus, the big thing about the First Amendment, what they're supposed to be doing, asking why is this case still sealed? They won't report on that. It's like it's a non-issue. But if somebody sues them, I think there was a story that came out that Mr. Kohberger was a cannibalist or something a couple of years ago. I can't remember who said it. Or somebody else sues them for defamation. They're going to run quicker than you can imagine to be protected by the First Amendment, freedom of the press. And they will not run one story about how disgraceful it is that this case went for over 2.5 years, the precedent that it may be setting, the danger that it may be presenting to the people's right to know and to be able to talk about this case. 2 months, 3 months after he pled guilty, they won't touch that story, and I don't understand it. Yep. Heather's saying, but they'll talk about a whole lot of beep. Got to give a beep here. Sorry, I got to worry about my FCC license for my little podcast. Okay. All right, guys. It's over an hour. It's dinner time. And I want to thank you very much. Please share that last video that we did, because there may be somebody out there that filed a public records request that's not really sure. Or please tell people to look at Judge Marshall's court order. And let's just keep spreading the word. Write to your legislators. Talk about this case with your friends. Talk about it. Support the podcasters, whoever they are. Whatever side of the fence, they're keeping the case alive. People are still talking about it. When they move off this case, whether it is someone who believes that they got the soul in the correct person or someone who does not, they're keeping this case alive. So I just want to thank you all. This was a very, very, very impromptu live following up on our premiere. Please watch our content. We put out 4 episodes so far, breaking down what that critically important court order was. And make sure to subscribe to the channel, to do all those things, like, share, all the things that they tell you to do that I keep forgetting to ask for. I'd really appreciate it. Until next time, ladies and gentlemen, thank you very much for being here. Enjoy the rest of your weekend, your day, your evening, your night, whatever time it is. I'll be right over, Isabel. Big pot of chicken curry. Where are you, Isabel? Isabel's got, all right, we're going to all be over. I think there's about, 82 people still in here. We'll be right over, Isabel. Thank you very much. All right, guys, we'll see you next time. Thanks for being here. Thanks, G-Wiz. Thank you, everybody.